Hello to all our viewers out there. It's a pleasure to be here with you today. I am Christopher Nudo, attorney at law, and I serve the Chicago community and Christ in the estate planning and real estate areas of the law. And today we are going to share about the estate planning process, and we're going to talk about how I help the neighbors and local community plan for when they're going to die. Just a little background about me. We have offices in Arlington Heights and in Elgin, and we have opportunities to meet with you virtually, and under special circumstances, we've been known to come and visit you as well. Today, I'm going to explain some often misunderstood and not appreciated concepts about estate planning. And we're going to talk about the goals of what an estate plan is. Now, often people call me and they say, "Hey, Chris, can you draft a will for me?" And that is the most basic estate planning concept that everybody understands. As a matter of fact, I feel that when we're born, we know to ask the question, should I have a will when I die? But let's unpack that question for just a moment. What people are really saying is, Chris, can you help me so that when I leave this earth, all of my assets can easily be transferred to my children, my spouse, a church, a charity, other people that are important to me? That's really what they're asking when they just ask the simple question, "Hey, Chris, can you create a simple will for me?" Now, there are many instances where a simple will is a good idea, and we will go through that. We'll even go through what a will is and different types of will. Um, what we're going to do is I'm going to explain some of these concepts, go over them, and then I'm going to leave some time at the end for some questions, and we'll try and see what our audience today has to share. So again, as I kind of mentioned in the beginning, what's the difference between having a will and what us attorneys call a complete estate plan? A complete estate plan is really a batch of documents that, when put together, take care of you during your lifetime in the event of some form of incapacity, and also helps your loved ones when you die. A will is merely just an expression, a written expression of your wishes of what should happen to your stuff, your whether they be your personal property, such as your frog collection or your jewelry or your cars, and real property, your house, your condo, things of that nature. What should happen to those things when you die? And a complete estate plan always does have a will involved in it, but then it has other documents such as healthcare powers of attorney, property powers of attorney, which are often called financial powers of attorney. Many people incorporate a living trust, and we'll go over those details today. And a document that's called a living will. Here in Illinois, it's called a declaration. And when you put all of these documents together and you learn how they work together within one another, then you can call that an estate plan. Now, what are the different types of wills? Well, first of all wills have the same purpose. And that purpose is to transfer assets from somebody who has passed to people who are alive. And but some wills are very simple, meaning that the assets within the trust get, the assets within the will get transferred outright to the people who you wish to leave them to. For example, you are elderly and you have adult children, and it's your wish when you die that your assets just get given to your children. That is a very simple will. That is, by the way, called an outright gift. But there's many instances where tragedies happen in families and people die at a young age where they leave children um, who just don't have either the age or the wherewithal to take care of the assets that their parents are leaving them. Best example of this is if a parent dies and leaves teenagers. In that instant, we can do wills that have testamentary trusts built into them. And these are just fancy words for saying the will establish a children's trust after the parents die, if when the parents die, the children are still minors in age. Wills can be written in many ways with lots of variants in them. I always like to say that any of our estate planning documents can be tailored and customized to fit your needs. We just use the English language, pen and paper, and through the magic of drafting, we like to customize our wills to your needs. So does a will need to be part of every estate plan? I alluded to this earlier, and the answer is yes. So even when we do an estate plan that includes a living trust, which the living trust in this instance is usually the cornerstone of any good estate plan, a will is also included. And why is that, you may ask? Well, the reason for it is because we always want to make sure that whatever your intentions are for what happens to your assets at the time that you die, that there is a written expression of your wishes at that time. Now, if a plan is designed properly, in most instances, a will not be necessary. But we never want to be in a circumstance where a will is necessary in order to transfer title to an asset and it's not available. So like I mentioned, every estate plan that we put together has a will of some nature, which is, again, nothing more than a written expression of your wishes for your assets to whom they should go when you pass away. So that leads us to the question, why do people create trusts? And the answer is, there's really two good answers for why people create trusts. The first one is because a trust does not need to go through what's called probate here in Illinois. The probate process in Illinois is a process that administers your will when you die. So when you die, your will must be filed in the county that you resided in when you passed away. And then if we need to transfer assets after you died that are controlled by the will, then we must take your will and have it admitted into the probate court. Now, this process is a very time-consuming, expensive, and relatively complicated process. As a matter of fact, just to put some framework around that, the average probate in our area takes about 14 months and can cost on average around $12,000 to $18,000. And the benefit of probate is not to your children, but the benefit is to creditors. The probate process is really designed to protect the creditors of your estate, not to easily administrate and transfer your assets to your children or loved ones. So we do trusts so that we can avoid this probate process. Trusts avoid probate simply because the probate process is designed to have jurisdiction over deceased people, and a trust does not die when the person dies. And so the administration of the trust through the language within the trust just continues after a person dies. So avoiding probate is the first reason why most people use trusts. Second reason is because we can design very effective ways to deal with minor children. Let's define what a minor child is. Most people think that a minor child is a child that's 18 years or younger, or possibly even 17, and when they turn 18, they're not a minor anymore. And while in many instances of our society that would hold true, I believe when we're talking about a good estate plan, that a minor is a child that is 25 years old or younger. Let me explain why I would create a definition like that. When young people inherit money, they typically have not had any experience managing money, spending money, or truly what the value of that money is. And if you look at our society, children don't have an opportunity to really um, manage money until after they come out of college. Many times, really isn't until they have married, after they've married somebody, that they really understand that there's a lot involved in managing money. So if we plan a good estate plan with a living trust, then we can set up guardrails for the children so that they only get access to certain amount of money on a scheduled period of time so that they can learn how to properly manage this money, learn how to properly spend it so they don't get themselves in too much trouble. It's no different than the way we treat children as we raise them. We don't instantly give a child a super sharp knife when we're teaching them how to use silverware. We give them a butter knife and we teach them how to spread peanut butter, perhaps. And then we graduate them into sharper knives to where they learn how to cut a steak or something of that nature. With our trust, we're doing the exact same thing. We're just slowly teaching them the value of money and the proper way to manage money. And in that process, we're slowly opening up the amount of money that they inherit over a period of time in a controlled fashion. Lastly, trusts can manage larger estates with regard to estate taxes. And here in Illinois, we're one of the states that has an estate tax. And estates that are $4 million net worth and above are subject to estate tax. And so a properly designed living trust for a husband and wife can minimize or eliminate any estate taxes. And so this would be a extremely valuable reason to have a trust. So is it ever too late to start planning for your death? And the answer is yes, it is. And this happens all the time. People wait just too long. What are the instances in which you've waited too long? Well, without being too cute about this, if you die, it's too late, right? Um, However, a lot of people don't die. What happens is they lose their cognitive ability. They cannot, they get some form of dementia or Alzheimer's, which again is a form of dementia. And in those instances, it's too late to plan. You must be of sound mind to execute a good estate plan. So my recommendation is get an estate plan done. Something is better than nothing. I hear all the time, well, I just didn't know exactly how I wanted to leave my estate, so I didn't do it. Well, I understand that dilemma, but my recommendation is get something down that's reasonably comfortable for you. And you can always amend it over time, because not doing something can always be far worse than doing something that's slightly less than perfect. So, what are the costs involved in creating a basic estate plan, and can the fees be spread out over time? And the answer is uh, the answer has many layers to it. So let's kind of unpack this for a minute. The four main tools in a good estate plan are a trust, a will, power of attorney for healthcare, and a power of attorney for property. Often, lawyers will design packages, and so and include many other documents in their package. A basic estate plan that just has a will, power of attorney for healthcare, and a power of attorney for property. Those three documents on average are about $1,100 to $1,200 when done through a firm like mine. When you're looking at a living trust estate plan that has many more documents, but also includes those documents and a living trust, the costs are somewhere between $2,500 and $4,000. And as you can imagine, there's many factors that play into the range between the low end and the higher end. And you may ask me, Chris, is the high end the highest end? And the answer is no. The uh, uh, Trusts can be extremely sophisticated, and the variance that defines the sophistication of a plan is how much money you have. Net worth clients that exceed $5 million start getting into plans that are more expensive than the price ranges I've mentioned here. And as always, prices are subject to change based on the changes that take place in the law. Can fees be spread out over time? By the very nature of the estate planning process, fees are spread out over at least a 30-day period. In addition, under appropriate circumstances, we work with clients on payment plans where payments can be spread out over as many as 6 months. We take those on a case-by-case basis. So a question I hear all the time is, why should I work with a lawyer when it's clear to me a simple Google search will allow me to find many websites that state that they will prepare these documents for me? Well, I always like to caution my clients that while these websites are well intended and yes, less expensive than working with an attorney, there is a grave risk that comes with working with these websites. And that risk is that the documents don't get executed with the proper formality that is necessary to make them effective. In the world of estate planning, how the documents are executed is just as important as how well the documents are drafted. If a will, a trust, or a power of attorney does not have the proper formality in the execution of it, then it completely invalidates the document. No different than if the document is drafted incorrectly, no matter if it's executed perfectly, the document is not valid. So these documents are very complicated in their, not only their drafting, but in their execution. And so I always caution people not to use the online drafting systems. Also, as you can imagine, online drafting systems spit out boilerplate documentation. And if you have some form of customization you want to make, such as the children's trust that I described earlier, those systems just won't have the sophistication to do those types of things. Now let's just recap for those of us that are just joining us now. Again, my name is Christopher Nudo, and I'm the founding partner of an estate planning and real estate law firm in Arlington Heights. I also have an office in Elgin, Illinois. We serve the greater Chicago community, and I am a Christian, and I should probably lead with that because Christ is really over all of my practice. Daily, my staff and I devote all that we do to the Lord, knowing that all that comes from what we do and who we serve is not only the will of the Lord, but we gain our strength from that. And we take great pleasure in helping our neighbors and the community getting their estate plans done, their wills, their trusts, their powers of attorney. We'd like to welcome you here every Friday. It's our plan to be on at 10:30 Central Time as we share all kinds of tips and legal guidance for parents, guardians, and other professionals. Now, while I've been sharing all of this with you, a whole bunch of questions have come in. I'm going to see how many of these I can get to with the time we have allotted. Let's go over some of them. Question number one that came in is, if I am a business owner, should I create a trust that owns my business? What a great question, and thank you for it. The answer is it depends on your business. So if you are a small business owner in a business that's not highly litigious, then I always recommend that your trust owns your business. And that way, when you pass away, the ownership of your business gets transferred to whomever is important that you have specified in your trust. Now, there are certain circumstances where you can't leave your business in your trust. A good example of that are attorneys. If we do joint trusts with our wives can't be owners of our law practices unless they're lawyers themselves. So what we do in those instances is we can leave the business to the trust on a transfer on death basis or other ways of dealing with that. That was an excellent question, though. And for the most part, I would say yes, your business would be owned by your trust. Oh, this question kind of looks like a follow-up question of the same kind. What's the difference in an estate plan strategy for an entrepreneur compared to working with a corporate job. So entrepreneurs, I work with them every day. I love them. As a matter of fact, I consider myself one of them. And entrepreneurs just seem to have lots of irons and lots of fires. And so it is very, very important that when I'm working with an entrepreneur, I work with them to get all of those irons focused into their estate plan so that when they pass away, there's no loose straggling accounts, assets, businesses, things of that nature. People who work in corporate jobs, it's much, much easier. We just make sure that the assets that they have are controlled by their trust when they die. So working with entrepreneurs just take a little more effort and TLC to ensure that all of their grand ideas and things that they're doing are considered when we put the estate plan together. This is a good question. I think we already answered it actually. What will happen if I create a will online and I did it wrong? Well, so here's the thing. People create wills online all the time. The problem is they don't know that they did it wrong. And unfortunately, most people won't find out that they did it wrong because it will be discovered that they did it wrong after they died. Because there's no red flag unless you have the will reviewed by somebody who knows whether the will was done correctly or incorrectly. There's no immediate trigger that would let you know you did it wrong, and nobody would intentionally create an invalid will. So what I tell people is, first of all, you're best not to do it yourself. But if you do it yourself, then take the time and have it reviewed. Pay a professional to make sure that it's correct. Because if you die and your will is not correct, either in form or execution, then that will be invalid, and it'll be your estate will be considered that you died without a will, because we cannot fix the will and whatever is wrong with it after you have died. What a great question, though. I appreciate it and thank you. All right, what else do we have here? How can I know if the documents I have will adequately protect my assets? Good question. First of all, I want to start with saying that in Illinois, we don't have an asset protection statute. What does that mean? That means that doing a living trust is not a way to hide or protect your assets from people that you owe money to or other types of creditors, such as lawsuits and things of that nature, as long as you are alive. Now, there are definitely some asset protection virtues of living trusts, but they don't have any effect until after you have died. So if you're trying to protect your assets, then we do have a few strategies in which to do that, despite the fact that we don't have an asset protection statute here in Illinois. One of the requirements is you must be married for us to take advantage of one of those asset protection methods. I don't think this is the time or the place to really get into these rather highly sophisticated methods. But what I would tell you is, if you have any concerns regarding asset protection, then you should give us a call and we should discuss what, if anything, we can do to help with those concerns. Next question. I love this question because I get this question all the time. If I remarry, do I have to update my will? I think everybody knows the answer to that one, right? And the answer is most likely typical lawyer answer, right? Not a yes or a no. No, really, I would say everybody needs to update their will if they remarry. Well, why? Well, your existing will, probably in some capacity, includes your former spouse. And unless you want your former spouse to be somehow involved in your estate when you die, your will or trust needs to be updated to include your current spouse. Also, if you have children from your previous marriage and children from your new marriage, these are considerations that will need to be taken care of. And that's why I always say that your estate plan should be reviewed. Number one, if you get divorced, and number two, if you get remarried. These are called life events, and plans should be updated anytime there's a life event. All right, next question. Are there any provisions I can add to protect my children from getting access to inheritances before they are ready? Yes. And if you have been with us since the top of the hour, you would know that in a living trust or a will that creates a trust, we can design very specific provisions for children based on age, based on life events, where where children can have access to their inheritance, but with controls in place, meaning that if they need money for college, it's available for them, but they need to go through a trustee. And the trustee has an obligation to pay for these things for your children. But we don't give an unlimited access to the inheritance to the children. We stage it, and typically staging is based on age. A lot of people say, Chris, can you give me an example of that? Sure, no problem. Oftentimes, we will say that at age 25, a child can get 1/3, 1/4 of their inheritance. At age 30, they have access to yet another portion, perhaps another third. And then at age 35, they can get the balance of the estate if we divided it in thirds. Is there any magic to the percentage that we're allocating or the ages that I designated? No, there's no magic to that. I would just tell you that those are typical ages and distribution schemes for your average family that has a net worth of $3 million or less. I have done plenty of plans where children schemes go all the way out till the children are age 50. Yeah, 50, crazy, huh? And I've also done schemes where distributions happen at 18, 21, and 25. A lot of it depends on the values that the parents have. It also a lot depends on how much money we're talking about. Typically, the greater the values of the parents and the more money they have, the more elaborate the distribution scheme is. All right, next question. What happens to investments, retirement funds, 401ks, or other financial assets after somebody passes away? That was a long question. That was a good question, though. So I'm noticing in this question that they identified very specific items: investments, retirement funds, 401ks, and other financial assets. These types of accounts are typically contract accounts with institutions, and these accounts have beneficiary options on them. What is a beneficiary option? A beneficiary is somebody named on the account to which ownership should transfer upon the death of the current owner. And so all of these accounts should have some form of beneficiary designated, whether it would be your spouse or your children, nieces, nephews, churches, charities. It doesn't matter. What does matter is that some charity, church, or person is listed versus there not being any beneficiary listed. Now, how do these accounts tie into the estate plans that we've been talking about? And the answer is that what we like to do is make sure that these accounts name your trust as the beneficiary at some point, so that when you pass, the assets within these accounts get transferred to your living trust, and your living trust controls the distribution to your estate. All right, let's see. A couple more questions, and then I think we can wrap up here. If I have a limited budget, what documents should I have prepared first? Excellent question. If you have a limited budget, I would definitely do the simple will, power of attorney for property, and power of attorney for healthcare. Those three documents are the essentials. And if you own a home, we would also want to do a TODI, transfer on death instrument. TODI, transfer on death instrument. This document will permit your house to be transferred without it going to probate when you die. All right. How old does my children have to be to take over real estate? In Illinois, the answer is 18 years of age. I honestly don't think that any 18-year-old is mature enough to manage real estate, but legally, they can own real estate at age 18. If I have property in other states, like Florida, what should I do to protect those assets after I'm gone? Excellent question. Real estate in any state should be controlled by your living trust. So at some point, we should transfer the ownership of that real estate into your living trust. What does that mean? Because people often think that we're putting something in something because that's the way we refer to it. What we're really saying is we want to change the title, the ownership name on the title, to the name of your living trust. That way, your living trust can control that piece of real estate. And the vernacular we use is that we are putting the property in the living trust, but it's actually not an in thing, it's an ownership thing. Us lawyers just like to make things confusing. Don't ask me why, we're just kind of born in that way. All right, do you offer virtual appointments or on-site visits? Yes, yes. My job is to serve the community. So really, whatever you are most comfortable with is what I am willing to do. I do virtual visits. I do in-person visits. Under special circumstances, I will travel to you. And otherwise, I have two convenient locations in Elgin, Illinois, and Arlington Heights, Illinois. And where can I contact you to set up a consultation? Well, I think they have this little cool banner that they put at the bottom of the screen, which will give you my website, my phone number, and all of my contact information. But uh, my website is nudo.net. It's my last name, nudo.net. And there you can get all of my contact information, phone number, email, forms to fill out, all kinds of things. So that's all the time we have for questions today. Um, I'd like to thank you for the questions. They were really awesome. I didn't even anticipate these many coming in, honestly. Um, I cherish this opportunity to spend the time and answer these questions and to help people. That's the beauty of my job. I wake up every morning able to serve, and that's what I really enjoy doing. Um, I encourage you to reach out to our firm so that we can discuss the estate planning process. The initial consultation is at no cost to you, and we would gladly share our experience, 30 years now of experience, and tell you how we would recommend that your plan is properly designed for you and your family. Um, I invite you to join me here again next week, Facebook Live, Friday mornings, 10:30 Central Time. And feel free to invite your friends, family, or to share this recording with fellow parents, family members, and other colleagues. So I hope to see you next week. Stay well and God bless. Christopher Nudo. Have a great week.